And a very good afternoon, goeiemiddag Molweni. You are still tuned into Sakisi's We're Building the Nation Podinas as the Western Cape Provincial Senior Commissioner at the Commission for Conciliation, Mediation and Arbitration, known as the CCMA. So your insights on workplace policies and labor regulations are invaluable. So today we'd like to focus our discussions on several key areas, including the CCMA's mission, employee working hours, and then also break policies, leave management, and salary review processes. So your expertise will help our audience better understand these critical workplace elements and how the CCMA approaches them. So joining us in studio is Vusumzi Landu, the Western Cape Provincial Senior Commissioner. So good afternoon. How are you today?
Good afternoon, and thank you for having me. I'm good. And yourself?
Can't complain at all, and it's just a pleasure to have you here, especially since we are in a new year.
Thank you.
So I can imagine the workload that CCMA is sitting with, as normally a lot of people tend to resign when it comes to December and so forth. So what is the main purpose of the CCMA, firstly? For maybe now recently we had matrics graduates, so they're going to come into the labor market.
Yes.
So they don't really know what CCMA is for because they can be exploited easily. So it is important that we also educate them that if their rights are not met, that this is the entities that you can reach out to.
No, of course, that's very much critical that we always keep our listeners and our community abreast in terms of the work that we are doing. Well, as you know, that CCMA stands for Commission for Conciliation, Mediation and Arbitration. Now, we get our powers from our Constitution. Section 23 of our Constitution talks about the right to fair labor practice. And then you've got your Labor Relations Act, which kind of provides the mandate of what the CCMA is supposed to do, which basically says the CCMA must advance economic development, social justice, labor peace, and the democratization in the workplace. So what CCMA does is to make sure that there is fair and equity in the workplace and that all employees are treated fairly and that there is no discrimination that is visited upon them. So we deal with your unfair dismissal disputes, we deal with your unfair labor practice disputes, we deal with your unfair discrimination dispute, and sometimes disputes that relating to monies that are owed to the employees. That is, in a nutshell, what the CCMA does.
Let's say, for instance, I become an entrepreneur and I start my own business.
Yes.
So currently my business is not a registered business because it's a hustle. But I have employees also working for me. Are they also allowed to come to the CCMA if they do have disputes?
Yes, any employee has got the right to come to the CCMA. Be it working for a small enterprise, medium or big. But what then one must also bear in mind that we've also got what is called the bargaining councils, which takes the bulk of our work in terms of the sectors. So for instance, you've got employees in a textile industry. They've got their own bargaining council. So those workers that are working in a textile, their dispute might not necessarily come to the CCMA. But if the employees are not covered by any bargaining council, then they've got a right to come to the CCMA. And remember, it's not only about the resolution of dispute, but it's also about prevention of dispute. So we've got a dispute management department that focuses on training employees and employers in terms of understanding the do's and don'ts insofar as the workplace is concerned.
So in the past year or so, have there been any new initiatives implemented at the CCMA?
It's a moving target. Because remember, whenever there is a new legislation that comes into place, the CCMA must always make sure that it acts in terms of that legislation. If the courts pronounce, the Labour Appeal Court or the Constitutional Court pronounce on any issue, then that affects the labour market. The CCMA have got to make sure that it deals with that and implement it accordingly.
the Basic Conditions of Employment Act, which establishes guidelines for working hours, but implementation varies across industries depending on which career you are at. So what are the most common working hour disputes the CCMA normally addresses? Which approach do you use for the resolutions?
Look, as you correctly point out, that it's not one size fits all in terms of the hours of work. It depends on the industry, it depends on the size of the employer. But normally you will find out that most employees have got their working hours from Monday to Friday, which the Basic Conditions of Employment Act regulate that they must 45 hours for a week or 9 hours in a day, with a lunch interval of at least 1 hour. Your typical dispute that might come before us is the dispute where the employees are saying, I've worked more than 45 hours in a week, I'm entitled to overtime, but I was not paid overtime. Those are the disputes that might come before us. Some of the disputes that might come us is when the employer faces economic pressure and they decide to reduce the hours of work into what is called a short time. And those employees who are aggrieved by such may come to us. So those are the kind of dispute relating to time, working hours that may come before the CCMA.
And then it's very tricky when we do speak about working hours also, because pre-COVID, a lot of people were able to work remotely and
Yes.
a lot of companies still have that in place. Like, how is the CCMA approach to working hour disputes involved around that, the remote working? Like, what guidance can you basically offer for employees implemented in that system? Because you're not able to really monitor
Yes.
how long you are working because you're working from home.
No, it's a very good question that you're asking. And we have not really developed, and there's no jurisprudence or law in terms of this area. It's a new area that the employers and employees are still navigating on it. But what I can tell the employees is that it's very much important that if your hours of work is from 8:30 to 4:30, for instance, and you are working remotely, remember from that time, it is very much important that you always avail yourself to the employer. If the employer sends you an email, it cannot be that you take 2 hours in responding to that email without any plausible explanation. In these days, you will find they have linked telephones to the laptops. So the employer will not phone you on your cell phone where you will go to a shopping mall and think that you will be able to respond to the calls. The employer might phone you on your laptop and you might have left the employer at your place. And when the employer does not get you, that might be tantamount to you committing misconduct. So it is very much important that even if you work remotely, you are aware of the fact that you are still under the control of your employer. You avail yourself up to the time in terms of your contract that you have agreed upon. Your lunch is normally, let's say, from 12 to 12:30 or from 12 to 1. But for whatever reason you want to take an early lunch or a late lunch, please advise your employer that I might not be available from this time to that time because I will be taking lunch, so that you don't find yourself in a situation where you have to face a disciplinary hearing. But the guidelines in terms of how this remote work should be done, I believe that there are people who are still considering them in terms of how can we make sure that this remote working is becoming part of our law. But for now, it is not. But generally, you should be able to understand that as an employee, you are bound to respect and comply with the legislation that confronts your workplace.
And when it comes to remote working, I'm sure you also experience this already.
Yes.
Like, you tend to lose time when you are working because you're working in your own space. So
Indeed.
you don't really monitor how long you've been working.
Yes.
So are you entitled then to claim overtime for those hours? Let's say your working hours is from 9 to 5.
Yes.
So
Remember, the issue of overtime, it's not really up to the employee. So in other words, the employee cannot just decide that today I want to work overtime. There must be an arrangement and an agreement with the employer that today, because of whatever deadline that one has to meet, I will have to work overtime, and the employer agrees to that. So if there is that arrangement between yourself and the employer, then the employer will be obliged to pay you. But if you decide on your own to be innovative and work extra hours without getting a permission from the employer may refuse to pay you unless your contract is so flexible that it allows you on your own to decide working overtime. But generally, an overtime is not a natural decision. The parties, which is the employer and an employee, must agree on working overtime and how much that overtime is going to be.
And then also, very importantly, when you are corresponding with your employee, for instance, or your employer, would you say it advisable when you're having communication, what that you do it via email or WhatsApp, so that it's able to be track the conversation instead of having verbal conversations?
Yes, indeed. Even if for whatever reason you had a telephonic conversation, it is very much important so that there are no misunderstanding. You are on the same minds, as the lawyers will say, the meeting of the minds. Because remember, one of the requirements for a contract to be valid is that there must be meeting of the minds. So it's very much important that whatever you agreed to telephonically, you reduce it into the writing by way of an email to say that as per our telephonic conversation, so that the employer might respond and say, no, this is not my understanding. Or the employer must simply confirm that this is the understanding. So do not only rely on verbal communication, because sometimes you might also have misunderstood what the employer meant to say when you were engaging on whatever specific issue you were engaging on.
Definitely. And then the law also requires specific break periods for employee working certain hours. And that is what you spoke about.
Yes.
If you work, for instance, 8 hours. We just need some clarity around how long your interval break needs to be. Like, what are the most common lunch break problems you see employers making when it comes to this? Like, how many hours do I, for instance, need to work before I am entitled to a lunch break?
Okay, no, thank you for that question. Remember, the Basic Conditions of Employment Act provides that if you work for more than 5 hours, you are entitled to 1 hour break. So that 1 hour break per arrangement between yourself as an employee and the employer could be divided into 2 or 3. That the 15 minutes will be regarded as a tea break, 30 minutes will be regarded as a lunch hour, and another 15 minutes will be regarded as another tea break. That will constitute an hour. Sometimes you will say, no, I just need my whole hour, and therefore I don't need tea breaks. So if typically you are working a 9 hour a day, then you are entitled to 1 hour. How do you want to spend that 1 hour is between you and the employer. I will take 2 tea breaks and 1 hour. Sometimes people will say, I will take tea break and then I will spend 45 minutes as my lunch. Then that constitutes your hour. So it's an hour in the event that you work for 9 hours.
And just some clarity around that, because I know I also came from retail,
yes,
and there was a lot of disputes around that. Where is it compulsory, like you've mentioned now, that your tea breaks actually comes from your lunch break, and
yes,
a lot of people or employees feel that you are entitled to a tea break also. So just to set some clarity that your tea break and your lunch break is technically, it's your lunch break. That tea break comes from your lunch break. It's not a separate additional 30 minutes that you receive.
Exactly. You are entitled to an hour. That hour is inclusive of your tea breaks and lunch. So normally people will take 15 minutes as tea break, and then another 15 minutes later in the afternoon as tea break, but during 12 to 1, and then they will take that 30 minutes as their lunch hour.
So you're not entitled to that whole hour. It's just important.
Yes, it's
that
very much important. Yes.
That about salary increases, working hours, and also leave entitlements. Now is the time to do that. So drop us that WhatsApps on 061-862-1065. And we are speaking to Vusumzi Landu, the Western Cape Provincial Senior Commissioner at CCMA. How have employees managed the leave management practice evolved over the recent years? Like, what common misconceptions do you encounter regarding statutory leave entitlements?
Look, any employee who works for more than 24 hours for one employer is entitled to a leave. Now, the Basic Conditions of Employment calculated in the sense that for every 17 days that you have worked, you are entitled to 1 day of leave. And therefore, what is also imperative is that we have noticed that many employees forfeit their leaves. Because remember, when you have your leave, you must spend your leave within 6 months from the day you have accrued your 21 days, if it's 21 days. So if you've in a year, let's say from a date that you started, and then you had that 21 days or 10 days that you have not spent, you must spend it within 6 months from the expire of that time. Now, the common mistake that is done by the employees is not to engage their employers to say that, hey, I'll note that I've got these few days leave that are still outstanding, but for one, two reason, I could not be able to use it. So that you can enter into an arrangement in terms of when are you going to use those days. Otherwise, you run the risk of forfeiting those days over a period of 6 months since we have accrued them. So it's very much important that we manage our leave, because the law is very much strict that you need a rest period. You cannot work for more than 18 months without any rest period. It poses health and safety concerns. So it's very much important that employees should manage their leaves. Their line manager should also be able to remind them in terms of how many leaves they have accrued and how many leaves they are entitled to take in every leave cycle. So one of the things that we normally get is that the employees, when they leave workplace for whatever reason, either they are dismissed or they've got new offers or whatever the reason that may be, employers may refuse to pay those excessive leave days, because the employer will say, you didn't have an agreement with me to keep these days, and therefore I'm not going to pay you for this. We are forfeiting it. So we get to those kind of disputes that come to us. And also what is important is that to note is that if you are serving a notice that you are leaving this workplace, you cannot go on leave while serving notice. So you must, before you serve your notice, make sure that you have exhausted all your leave days before you serve the employer with the notice. Remember, notice depends on for how long you have been with the employer, also in terms of your contract. Some notices you must give the employer 30 days notice before you leave for another new place. So before that 30 days, make sure that you have exhausted your leaves, or you have an agreement with the employer that you don't need to take your leave. I'm going to pay you whatever balance is. Do not just simply assume that at your exit, the employer is going to pay you whatever is due to you.
Definitely. And then just a quick question, like you've mentioned, let's say, for example, you get the 21 days of leave and you need to take it within that 6-month period.
Yes.
So does that also include, like, if you work from Monday to Friday,
yes,
does it also include the weekends in those days to accumulate to 21 days at the end of the day?
No, if you work from Monday to Friday, so your leave cannot include the weekends, because you don't work on the weekends. Cannot include the public holidays. So your leave, you calculate and excludes every weekend that might be, and excludes every public holiday that might be.
Okay, so we just have some WhatsApp questions also. Basically, what the listener is asking, how is annual leave calculated for employees working a 5-day week compared to a 7-day week?
I think the trick is not to calculate it on the basis of whether you work 7 days or 5-day week. The trick is to calculate on the basis of what the basic condition of employment informs us or provides, that for every 17 days that you have worked, you are entitled to 1 day leave. So if you work 7 days, you will say, I've worked, but normally, even if you work on a 7th day, there might be, that will be a shift worker, because that's not normal that you can work 7 days. You must have some rest days in between those. So you will say that I have worked 17 days now, and therefore I've got 1 day leave. And then you start from another next 17, you calculate it 2 days and so forth, up to the point where you say, some employers might say that in terms of your contract, when you've got so many years and then your leave accrual, it's 1.5. So it's no longer now 1 day, but it's 1.5. Or sometimes they might say it's 2. So also it depends on the nature of the contract that you have with the employer. But if you follow strictly the Basic Condition of Employment Act, it will tell you that every 17 days you are entitled to 1 leave day.
Definitely. And I think you also answered the second question, but basically what the listener is also asking, if the Basic Conditions of Employment Act states that employees are entitled to 21 consecutive days of annual leave, does this mean 15 working days for a 5-day worker?
Yes.
And that is basically what we
Yes.
just discussed now.
Exactly.
And then there's another one that asks, how should public holidays that fall within annual leave be handled?
As I've said, when you take a 5-day leave, for instance, and then within that 5 day, there's a public holiday, which means you have basically taken 4 days. So the 5th day will go to the next week if you take a whole week. If you take a 5 days week and within that 5 days there's a public holiday, you will exclude that public holiday. And therefore it will mean that you have taken a 4-day leave instead of a 5-day leave.
Basically, you've also answered this question where it comes down to when workers and employees disagree about the leave.
Yes.
Like, how do CCMA Commission decide what is fair in that case? Let me rephrase that question. Let me ask it, if the employer is allowed to tell you, like, when you can actually take leave, because like you said, you need to take it within that 6-month period.
Yes. Now, what is important here to note is that in as much as you are entitled to leave, but it does not automatically mean that you can just wake up and say, I'm going on leave. You need to say, okay, I've got 10 days of leave, because the operations of the employer must also be taken into consideration. So you will say to the employer, look, employer, my line manager, I've got 10 days of leave, and therefore I want to apply for my leave from this day to that day. So that also the employer is given an opportunity to make sure that your gap is being filled. So the employer might say, no, but you can't take leave because this is the busiest time of our operations. But also the employer cannot simply refuse you to take a leave without fair and justifiable reasons. And also if, for instance, you've got that 21 days of yours and 12 months have expired since you have worked for this employer, as I've said, you need a rest period. So even with the operations of the employer cannot deny you to go on leave when you have not been taking leave for such a long time, because the law says you must have a rest period. Your body need to rest.
What constitutes a fair and legally salary review process according to the CCMA? Like, what records should employees have on hand?
Look, the issue of salary increase is what is referred as a matter of mutual interest. So in other words, it's not really regulated in terms of that, unless you are an employee, for instance, who falls below the threshold and therefore you are entitled to minimum wage. Now, if you are entitled to an increase in terms of the minimum wage, as we know that now from the 1st of March, the government have already promulgated that from the 1st of March 2025, there will be an increase for minimum wage. If you fall within that band, then the law decides on you how much you must get. But if you fall outside that band, and then you've got your contract that says you earn 30,000, for argument's sake, a month, and then the year ends since you have been working here earning that 30,000, you are not simply entitled to an increase. You have to negotiate it. And that's where trade unions play a bigger role in terms of negotiating what salaries increment should be to its workers. The employer can simply refuse to give you an increase on the basis that the contract that you have with the employer stipulate that you will earn 30,000 and the employer is paying you 30,000. Therefore, there will be nothing that CCMA could do in that regard. However, if you've got a power to bargain, that's why I'm referring to mutual interest. And therefore, what that means is that if the employer refuses to increase your salary, then your trade union or you as the employer's forum can therefore declare a dispute of mutual interest to the CCMA, and the CCMA will try to mediate, conciliate, and assist the parties in resolving in terms of what a salary increase could be. If that cannot be resolved, that's why you find the employer is going on strike to seek for better wages. So the long and short of it is that unless it is regulated in terms of the minimum wage or in terms of your contract of employment that every year, for instance, your increase will be 2% or whatever it is, you cannot demand or you are not entitled to that increment unless you follow the collective bargaining route.
And this is basically what you just spoke about, where the listener is asking what steps to take if you are denied increase for 3 consecutive years. So basically it needs to be outlined within the contract, and it needs to stipulate that it will increase with 2% or so. So it can't just say after 3 years, for instance, you will get an increase. So it needs to say by how much.
It needs to say by how much. And also, as I've said, that if then, in this example, you have been working here for 3 years, there has been no increase, your recourse is to get as much workers as possible who might also have been affected by what has been affecting you. And therefore, you can lodge a dispute with us of mutual interest. But it's very much important that if you are the only one who is not receiving this increase, but others are receiving an increase, and then that's a different dimension. And therefore, you can refer a dispute to the CCMA. That dispute will be called an unfair discrimination dispute, because they are discriminating against you if others are getting an increase and you don't get an increase. And therefore, the CCMA will consider that dispute and decide whether the reason provided by the employer why you are the only one who's not getting this increase, whether it's fair, justifiable in terms of the law.
And just to backstep a little bit quickly, when we spoke about leave, so for instance, like you've mentioned, you do get the 21 days, but what happens in a case where you might fall sick, for instance, or let's make an example, you have TB, for instance, so you need to be on treatment for at least 6 months. So that means your sick leave is not going to be enough to cover that. So how does that whole process basically work?
It is very much important to understand that we've got different types of leaves. And thank you for the question. You've got your annual leave, you've got your sick leave. Your sick leave in terms of the Basic Conditions of Employment Act, it will be 36 days over a period of 3 years. So over a period of 3 years, you are entitled to at least 36 days of sick leave. So if you go on sick leave for whatever reasons, and then you exhaust your sick leave days, and sometimes the employer will have what is called an extended sick leave. Sometimes in their contract it will say if you have exhausted your leave and you are still not able to come to work because of the nature of sickness you can be given another 60 days where the employer will still continue to pay you. Sometimes you've got those covered by your provident fund or whatever, that provident fund will be paying you for the period that you are incapacitated to come to work for that particular period. But over and above that, if you exhaust all of those, you might run the risk of having to be on an unpaid sick leave.
Okay, interesting. And then what happens in a case like you need medical proof for how many days?
Definitely. Remember, if it's 1 day, the law at least is kind of lenient that you don't have to issue a medical aid. That's why it's very much important to look at your contract. Because in some industries, because employees have the tendency to be on sick leave on Mondays or on Fridays or on any particular day. So the employers have drafted a contract that says that, yes, it's 1 day, you don't need a certificate unless it is on Monday or on Friday. And therefore the employer will say, even if it's 1 day, but if it's on a Monday, you have to produce the sick certificate, because some employees, that's the fact, that's the truth, they abuse sick leave.
But if the employer, for instance, see the employee is becoming a trend, are they entitled to ask you, but it's not stated in your contract, so are they entitled to ask you for proof?
Yes, because one of the things that the employers will do is that, remember, there's what is called an incapacity, where you will be dismissed for incapacity, not because you have done anything wrong, but because of the rate of your absenteeism in the workplace, for instance, to an extent that you can't really provide quality input to the employer. What the employer will do, the employer must take you to a process where the employer will bring it to attention that, look, Vusumzi, we note that every Monday or every after pay day, you are on sick leave. Is there anything that we might be able to help you with? these are the signs that we are noting. And then the employer will engage you. If you do not improve on that, and that could be taken as you abusing sick leave, it is very also much important that, and there's case laws to that effect, that when you are on sick leave, it is regarded as an abuse of it if you report ill at work, but you are seen on videos or on social media partying somewhere else on the very same day that you have reported that you are sick. There's a case of a guy who reported to an employer that he is sick, and the employer accepted it. Then, if you remember, there was a time when the EFF had issue with Clicks, and they went to demonstrate in all Click stores. The guy was seen at the front of people demonstrating at Clicks wearing an EFF T-shirt. And he has submitted a sick certificate. And the employer said, no, that's an abuse of a sick leave because you said to us you are sick and yet you were seen jumping, toying at Clicks. And that employee was dismissed. He took his matter to the CCMA. CCMA confirmed dismissal. He took it to Labour Court. Labour Court confirmed that the dismissal was fair. So it's very much important that even if you are on sick leave, you stay away from social media.
So when filing for a complaint to the CCMA, does a person always have to have written or shown proof? Because sometimes in our workplaces, we are verbally abused.
Yes, because in order for your referral to be compliant, when you send your case to the CCMA, unfortunately, you have to show proof that you have also served your employer with the same referral that we have sent to us. Because the employer, remember, has got a right to come and defend itself before us. And the only way that the employer can be able to come and defend itself if it knows that there is a dispute against it. And therefore, our case management officers, before they even process your referral to us, they will want to see proof that you have also sent the same to the other part, which is the employer.
Is it legal for an employer to change the pay system whereby you were paid a straight salary?
Okay.
And now you paid according to the days within the pay circle, meaning the company's month starts on the 24th and ends on the 24th other months. And it's more days, and other months it's less days, and so is the payment. So basically what they're asking, like some months has 31 days.
What is important, again, I'm going back to the contract. It is very much important that you familiarize yourself with your contract. Look at what your contract provides in terms of how you are going to be paid. So if the employer pays you and changes how the method of payment, and that is not covered by the contract between yourself and the employer, then the employer is in breach of that contract. It is what is called a unilateral change to terms and conditions of employment. And therefore, if the employer does that without any consultation with you and an agreement to do that, then you can potentially refer a dispute to the CCMA of a unilateral change to terms and conditions of employment. Because it's important that the employer pays you in terms of what the parties have agreed to in terms of the contract of employment.
Thank you very much for taking the time to speak to us today. So if anyone have further questions or want to know the procedures that they can follow, because I know you also do have an online system they can actually send their request to, how do they go about?
Look, we've got on social media platforms, we are available on Facebook, CCMA South Africa. We are available on YouTube, official CCMA. We are available on Instagram, CCMA South Africa. On LinkedIn, CCMA South Africa. We're also on TikTok, CCMA South Africa. But you can also send your query to info@ccma.org.za, or our contact number is 0861 161616.
Thank you very much for taking the time to speak to us today. And the important thing is that your services that you do render is free of charge.
Yes, they are free of charge, definitely. Thank you very much.
So thank you for sharing your expertise with us today, Mr. Landu. Your insights into these critical workplace policies provide valuable guidance for both employers and also employees navigating South Africa's labour market. And the CCMA's role in fostering fair labour practices continues to be essential for workplace harmony and economic stability. mobility in the Western Cape. So if our audience wishes to learn a little bit more about these topics or require assistance with the labor disputes, the important thing is to go visit their social media or go to their website. And like you heard, they're also on TikTok. So there is a lot of resources available at your disposal. And we also appreciate your commitment to promoting fair labor relations and look forward to seeing the continued positive impacts of this